Good afternoon, everyone, and thank you so much for joining us for today's training, Smarter Contracts, Protected Assets, Elevate Your Legal Protection. I'm Rebecca Chauncey, Interim Director for the Illinois Small Business Development Center, or SBDC at Bill Bronzeville. Pleased to have you with us today. Just a couple of housekeeping notes that you should be sure to type any questions you have in the Q&A section, which if you hover over the bottom of your screen, you should see that. There will be times when you will be asked to respond to the presenter's questions or statements, and you'll will respond to those via the chat. So just understand the difference. Again, quick responses to the presenter, type those in the chat. But if you have questions throughout the training, type them in the Q&A section because that allows us to organize them a lot easier. And know that this training is brought to you at no cost because it's funded in part through a cooperative agreement with the United States Small Business Administration, or the USSBA, the Illinois Department of Commerce and Economic Opportunity, and the Urban Juncture Foundation. And we're so pleased to have today's presenter, trademark and business attorney Shayla Jackson, who is also the owner of 180 Degree Contracts. I will let her tell you more about her background and talk to us about those smarter contracts, protected assets. Shayla, take it away.
Well, welcome, everyone. I'm excited to be here with you. And we're going to jump in today. So I want to welcome you to Smarter Contracts, Protected Assets. Now, before we get started, I got some questions for you, okay? And so I want you to answer these questions in the chat. The first question I have for you is how many of you actually have contracts? If you actually have a contract, a written contract, put me. Just type me in the chat. Do you actually have a contract? Type me. Okay. And then the second question, okay, nope, no contract. Okay, thank you for your honesty. The second question that I want to ask you, for those of you who have a contract, and even if you don't have a contract, but you have been doing business, I want you to put the highest amount that you have signed a single contract for or did business for. What is the highest amount on a single deal? Contract or no contract? What's the highest amount? And you can estimate it. Was it $10,000? Was it $20,000? Was it $1,000? What is the highest amount? I want you to type that in the chat. And look, don't be shy. Talk back to me, y'all. I know it's the afternoon, but talk back to me. Now, for some of you, you may have that dollar amount in the mind. You may be in your mind. You may be calculating it. And I want to ask you this: how confident are you that your contract, if you have one, actually protects you, that it protects your business, your intellectual property, and that it will hold up in court? And if you don't have a contract in place, then how confident are you that you will be protected, your business, your intellectual property, and that you would be able to win in court? I want you to think about that. Now, let me introduce myself so you understand who you're talking to. And so I am a trademark and business attorney, and I'm also the CEO and founder of 180 Contracts. 180 Contracts is a contract template company for small businesses, freelancers, and entrepreneurs, helping you to do contracts better by putting attorney drafted contracts in your hand that are the next best thing to hiring a lawyer and that won't break the bank. Look, the reality is that I have witnessed my law firm clients come to me with janky contracts that didn't protect them, that they found online. And I've had clients come to me who just didn't have the funds to hire me. And so from that experience, I created 180 Contracts to be a medium. If you cannot hire an attorney, which is the best thing for you to protect your business, then my contract company, 180 Contracts, I created it to be able to protect people in the meantime. And even if they can hire an attorney, oftentimes the cost of hiring one to draft every contract in your business can get expensive. And so I created a company that would be affordable. So I have my own law firm, Legacy Legal and Consulting Firm, and I have been licensed to practice law for, y'all, it will make 10 years this year that I graduated law school and passed the bar exam. I have been practicing for almost a decade. And so I graduated from Georgetown Law. I started out in criminal defense, education law. And then when I graduated, I transitioned to business law. And my firm in April will be celebrating 4 years. But I didn't just start with law school. I had a business first. I had a photography business. And I remember knowing I needed a contract, knowing I needed an LLC. I remember knowing I needed to put some protections in the contract, but not knowing nothing about contracts. And now I look back and I am so glad I did not get sued because I just did not know what I did not know. And some of the things that I'm going to share with you today. I'm also a teacher, a trainer, and a coach. I actually spent 1 year in Georgetown Law's clinical teaching program, and I taught at Georgetown Law. I actually taught in DC high schools and DC jail the law. And so I come with a teaching background. I'm a Maryland native, and I'm also the author of my book, Build a Legit Business, which covers different areas of your business that needs legal protection because legal protection is greater than contracts. But today we're going to talk contracts. You see here below, I've been featured in different publications and also a speaker for different organizations. And so you can just Google me. There are a couple of new Shaylas popping up. So you just put Shayla Jackson and attorney behind it, and you can learn more about me. But today, let's jump in. So, legal disclaimer, I have to put this out here, is that 180 Contracts provides a legal product and it is not a law firm or provide legal services or advice. By you being here and by you watching the replay and participating and grabbing any resource, it is for educational and informational purposes only. This is not legal advice. Nothing creates an attorney-client relationship between me and you, 180 Contracts and you, and your business. And so everything in the materials is copyright protected. So please don't take screenshots unless I permit you to, and please don't record. A recording will be made available to you, hopefully. All right. And if you want written permission, then you just reach out to us. Now, I'm going to start this here because for some folks, you may have to go, and that's okay. But you can take a screenshot of this slide to stay connected to us. Our website, our email, follow us on social media, subscribe to YouTube, follow us on Facebook and Instagram. And we have a monthly newsletter that we send out every first Friday with legal goodies. All right. Now, because again, people may not make it to the end, take a screenshot of this as well. I have a free resource available that you can have access to called 8 Things You Better Hope Your Contract Covers. And you can get that by going to the link you see on the slide. Now, let's talk. Smarter contracts, protected assets. Smarter contracts, protected assets. Now, what is a contract? Because when we talk about smarter contracts, first we have to understand what a contract is. And so a contract is an agreement between two or more people exchanging a promise for something of value. It is an agreement to do or not to do something. And so a contract, another name for a contract is agreement. And so contracts require a meeting of the minds, agreement. And so when you have a contract in place, the meeting of the minds means that we are on one accord according to the terms of the contract. But contracts also require that there be an intent to be legally bound. And so that's why there is a difference between a promise that is a gift and a promise that becomes legally bound, an intent for both parties to enter into a legally binding agreement. So why do contracts matter? Well, first and foremost, contract matters to avoid and resolve disputes. So I don't know about you, but have you ever had the he said, she said, somebody cried wolf and said, you said something you didn't say? Well, when you don't have a written contract, now you're dealing with he said, she said, and there's nothing to point back to. Contracts help you avoid disputes, but they also help you resolve disputes. I don't know about you, but some people, I used to do this. I don't do this anymore. I don't have this anymore. But some people, some of us still have this when it comes to disputes and conflict. Somebody does something and maybe you feel a little type of way about addressing the behavior. A written contract will help you address bad behavior by pointing to the contract. You agree. Remember when you signed this contract? Well, now I'm addressing the bad behavior and asking you to get in line, right? Get in line. That is what I'm asking you to do. The second reason why contracts matter is it helps you mitigate risk. Anytime that you do business, there is risk. There is always risk in business. But what a contract does is it allows for you to mitigate the risk. You can assign risk, you can reduce risk, and you can also avoid risk. But you do that in the contract. Another reason contracts matter is to secure and protect your intellectual property. If you hire someone, if you hire someone to create something for you, the creator of that work owns it, which means that if you don't have a contract in place, you don't own what you hire someone to create for you. That's why contracts are important because transfer of intellectual property cannot happen without a written contract. Another reason why contracts matter is to clear up confusion. Sometimes when you're talking, there could be confusion about what someone meant or what exactly was the deal. The contract is an area where you clear up confusion. Here is what we actually agreed to. And last but certainly not least, contracts matter because certain contracts are required to be in writing or they are not legally binding. All right, so this is why contracts matter. So, how are contracts formed? Because not all contracts are required to be in writing, but it is good practice to put it in writing to avoid some of the things that I mentioned just a moment ago. So here are the requirements for a contract to be formed. I want you to think about this like a recipe. I don't know how many of you have ever baked, but baking is not the same as cooking. Cooking, you can be creative, you can wing it. But in baking, you cannot wing it in baking. You mess up an ingredient just slightly and it can throw everything off course. The same is true for contract formation requirements. You have to meet all of the requirements or you do not have a legally binding contract. You can have a contract, but it may not be legally binding, meaning it does not hold up in court. So, in order for a contract to exist, you have to have a clear and legal offer. You have to have a clear offer. The other thing you have to have is consideration. Consideration is the bargain of that. What is the bargain that is being valued? The value of the bargain being exchanged between the parties. So we're bargaining. What is the value? And so oftentimes that's an exchange of services and money, money and services. Now, if you're doing something for free, free is not the bargain for it. So you have to identify what is the bargain of value. And oftentimes that looks like exposure to a new community. The third requirement for a contract to exist is that it has to be accepted to the original terms. If you counteroffer or a client for your carrier service counter offers on the fees, guess what? There is not a contract because they have rejected the original offer. So the acceptance has to be to the original offer, or that is a negotiation for a new contract. The other thing that you have to have for a contract to exist is clear and unambiguous terms. Anytime that there is left open for ambiguity in terms of the terms, chances are you may not have a legally binding contract or a contract. Because remember, I said that contracts require a meeting of the minds. If the terms are unclear, how can we be on the same page? So you have to have clear terms and they have to be unambiguous. There can be no ambiguity as to what a term means. The fifth requirement for a contract to be formed is there has to be capacity. So, what is capacity? Capacity means that both parties have the capacity to enter into this contract. Meaning, for many of us, we are of age. So you have the legal capacity of age. People who are under the age of 18, and I say people because I don't want to call them kids, not all of them kids, but young adults, they can enter into contracts, but the contract may not be legally binding because under law, the law recognizes that capacity is for those who are of age or the age of majority, depending on your state law. But what happens with children under the age of 18 is if they sign a contract, once they come of age, they have a certain amount of period to actually rescind the contract or come out of it. Now, why am I talking about children? Well, remember I mentioned intellectual property ownership. If you have a niece, a nephew, or a daughter or a son anyone under the age of 18 taking photos for you, maybe helping with your social media or your business, the work that they create, they have intellectual property rights in it. So just because they're under 18 doesn't mean they don't have intellectual property rights. And some of you may have children who are doing business. They are creating intellectual property and they have rights. But when it comes to entering into contracts, they don't have the legal capacity. And that's where understanding capacity comes into place. For us as business owners, the other part of capacity is being authorized to legally bind the business. Look, when you are doing business, whether you are doing educational consulting or this is a new real estate deal, you want to make sure that the person at the table you're negotiating with is actually the person that can legally bind the company. Why? Because if they are not authorized, then how can they enter the company into this contract deal and it be legally binding? And so one question you can ask is that, do you have the authorization? Are you legally authorized to negotiate and agree to this deal? This helps you avoid time, but also helps you to make sure that when you are in the negotiating space, that you can create a contract, a verbal contract, that even if they go back and change their mind, a contract still exists. The next requirement you need for contract formation is legality. This simply means that the contract is for something legal. And this, according to the law, the foundational principles of contract law, is essentially to just protect, according to public policy and just moral and good standing, that people are not able to hold people accountable for contracts that are for illegal means. And another requirement, and certainly not the last requirement, is the intent to be legally bound. That means that these parties knew what they were doing. Now, let me go back really quick to capacity. Capacity also means mental capacity, meaning that this person had the mental acuity to enter the contract. Just because somebody is drunk does not mean that contract may not hold up. And so capacity has different ranges to it when it comes to mental acuity. But with mental acuity, this is to help folks who have dementia or Alzheimer's, where their faculties have been diminished, that we don't want them to be held legally bound to a contract of someone trying to get over on them because they don't have the capacity to enter the contract. And so look, I feel it in me. I want to go into estate planning law, but I'm going to stay focused here. And if you are someone who has elderly parents or anything, just mention it in the comment Q&A section, and I'll touch on it when we get there, because that's important. And so, last but certainly not least, is that some contracts are required to be in writing in order for it to be legally enforceable. Meaning, if it's not in writing, it is not held up in court. But there are other contracts that you don't have to have it in writing, because contracts can be formed verbally. So you can have a verbal contract before you ever put it in writing. And this is why it's important for you who are here and watching the replay to understand contracts, because you want to be able to turn your conversations into contracts and then cash it in and convert it into cash and dollars, because contracts start as a conversation before you ever put it into a written contract. So what are the top 4 contract mistakes that you want to avoid? Now, I asked in the beginning, what was the highest dollar amount that you have ever had in a single contract or deal? And the reason why I asked that question is because one of the biggest mistakes that you can make is putting your personal name at the top of a business contract. I had a client, one of my law firm clients, who made this mistake, and the other party was threatening to breach the contract. Now, according to the terms of the contract, if she canceled, she would have been personally liable for $20,000, although the other party didn't do anything, because the way the contract was written. She made the mistake of putting her personal name at the top of the contract instead of her business. It was a business contract, but her personal name was there. That means that if she had terminated the deal the way she wanted to, she would have personally been liable for $20,000, not her LLC. Her LLC would not have protected her, because the LLC was not a party to the contract. She was. So you want to make sure that you are not putting your personal name at the top of a contract unless it's for the proper transfer of intellectual property. There are some exceptions. The second mistake that you want to avoid, and it's a top mistake, is listing the wrong party. Anytime that you have a contract, there are many people who do business under DBAs, trade names. It's not their original business name. You want to make sure that people, if they represent that they are LLC or they're representing themselves out as a particular business, that that is the correct party being listed. Because if it is not the correct party, then who did you enter a contract with? The other reason why this is important is because if you list the wrong party and you're trying to secure your intellectual property, but you list the wrong person who actually have the rights, that means you have a empty contract because you listed the wrong person. You cannot transfer rights that you don't own. Meaning if the person doesn't own it, you may have listed them, but now you still don't own your intellectual property regardless of what you put in your contract. Another mistake that you want to avoid is missing key contract clauses. And I'm going to talk about that in just a moment. Because if your contract, you have a contract in place, but you don't have the right contract clauses to protect you, then your contract really isn't smart. Your contract really isn't elevating your legal protection. It's still leaving you unexposed. And so you might have a contract, but you don't have a contract that can actually protect you and protect your assets. And another mistake you want to avoid, these are the top four contract mistakes, is DIY contracts from scratch. Look, I don't know about you, but if English was not your strong suit, if spelling and understanding the definition of words was not your strong suit, trying to DIY your own contracts from scratch when you don't understand contract law is a recipe for disaster because some contract lawsuits have literally been challenged on the placement of a comma, the placement of a semicolon. How does it change the definition of a sentence? And so doing your contracts from scratch, meaning you are starting over, is an area where if you don't understand contracts, you can leave yourself with a dumb contract or a contract that is just a piece of paper and will not hold up in court. Now, a bonus mistake that I have seen is people who borrow contracts or repurpose contracts. And so they may have a contract in one area and think that contract is universal for all other deals. And so, look, gaming is not the same as media production. Doing courier services is not the same as education consultant. Being a photographer is not the same as being a speaker. They have different requirements, different risks. They need different clauses, and they need to account for different things in order to be a smart contract that protects your assets. So understand that there is the power of words. Words have power and they matter because words carry legal weight. Words will make or break your contract, and words create legal rights. When you have a contract and you are drafting a contract, this is why, look, if English was not your strong suit in school, this is why it matters because what you write in the contract, you are creating legal rights. So words like shall and must create a legal obligation, but it also creates a legal right. Whereas words like may and probably and maybe or permitted, they create a option, but they don't recreate a requirement. You can also create privileges. So legal rights are they're honed in, but privileges are something you can take advantage of, but sometimes that privilege can be revoked. So words really matter. And look, the English definition of a word does not always mean the same definition in the legal. So the English is not always the same as the legal definition. And so an example of that is notice and consideration. So the English definition of notice is the English definition is consideration. You notice something, you become aware of it. But notice in the legal definition in contract realm is giving notice, making someone, the other party, aware of something. So you're sending a notification. Think about your phone when the alert pops off or an alarm. It's sending a notification, notice. But notice is not just a notification. It actually has to have something in it. Words. What are you notifying of? So you can notice someone has a lovely dress, consideration. That's awareness. But notice in the legal definition is I'm sending you official communication under the contract terms. The other thing is consideration. Consideration is the English definition, taking someone into account, taking their feelings into account, taking the business into account. You're thinking, you're meditating on it. But consideration in the legal and contract world is the bargain for exchange of value between the parties. Because if you don't have consideration, you don't have a contract. If there's nothing being bargained for, you don't have a contract. And so notice in consideration, they're the same word, they have different meanings, and they also have different outcomes. So you want smarter contracts that actually protect you. And you have to understand that there are some misconceptions that we as business owners, you didn't go to law school, you may not have learned about contracts, and even some of the information on the internet is like, who is telling the truth? You can get confused because one person is saying one thing and the other person is saying another. But one of the things is when you don't have the foundational knowledge of contracts or the law or laws of doing business, is that you don't even know where to start. You don't even know what you don't know. You don't even know what questions to ask. And that's the reality for any of us, including myself. If you don't know, you just don't know. And that means sometimes you don't even know how to ask the question to even begin getting on the journey and on the road to finding the right answer. Because the right questions will give you the right answers, but the wrong question will give you mixed answers. And so one myth that people believe about contracts is that you are safe with a written contract. We probably have heard it, seen legal shows, and like we got to have a written contract. But you learn that contracts have formalities, they have legal requirements. So just because you have a written contract, if it doesn't meet those requirements, there is not a contract or there is not a legally binding contract. It's just a piece of paper. And so the truth is, a contract does not protect you or your business. It is a well written contract with the right clauses and a contract that is used properly that actually protects you. So when we talk about smarter contracts and protecting your assets and elevating your legal protection, we're talking about a well-written contract that has the right clauses for your industry, for that specific topic of the business deal, the topic of the subject of the contract, but also that you're using it properly in business. Because if you have a smart contract, the contract is solid, but you make the mistake in how you use it, you make your legal protection null and void. And so we talked about some of those top mistakes. User error, putting the wrong name at the top of the contract. That's using it improperly, where you make your LLC the null and void. You have no legal protection. Listing the wrong party. That's an area of leaving your intellectual property, which is your money making, generating assets of your business left unprotected, left unsecured, and now you don't own the rights. Which means that, look, in this case, if you don't own the rights, that means that you're probably renting and somebody else can stop you for copyright infringement, because we're going to get to it in just a moment. And so you want to avoid that. So smart contracts, you can have a smart contracts, but they can become dumb contracts because of user error. So you want to avoid user error. Now, let's talk about elevating your contracts with some sample contract clauses. So I want to give you some clauses that will help your contract become a smarter contract, protect your assets, and elevate your legal protection. And so one clause, this is what you want in your contract. You want a venue selection clause, a venue selection clause. So for those of you who have a contract, I want you to look at your contract and I want you to see, do you have a venue selection clause? So what is a venue selection clause? A venue selection clause is what I call home court advantage. Home court advantage. Now, it's home court advantage because what I'm about to tell you is what I practice. But venue selection clause, what it does is it identifies where litigation must take place, where disputes must be resolved. And so oftentimes what you'll see is that disputes must be resolved in a particular state, or preferably, if you want a smarter contract, it should identify the county and it should identify the state. Because I want you to think how big Illinois is. Do you really want to be traveling to another part of Illinois when you're in Chicago? Chances are no, you don't want to spend that money. So a venue selection clause, this is where you want to identify the county and the state. But for many of us, we are doing business across state lines. And so you may be doing business with someone in Texas, New York, you may be doing business with someone in Georgia. And when you are doing business with people who your clients, they're in different states, that means that it is possible for you to get sued in another state, which means litigation costs go up. And we don't want to be spending money traveling just to sue or deal with a lawsuit. And so a venue selection clause, this is why I say home court advantage. When you are drafting the contract, you get to put home court. I don't know how many of you watch sports, but there's something about home court advantage when you're at home. You just have a leverage and advantage because you're familiar with your home location, your home. And so for your contracts to elevate your legal protection, you want to put where you are, your county and your state for where litigation must take place. This is how you reduce litigation cost. But if somebody is in another state, this is also a potential way to block lawsuits because they're not going to want to have to travel to where you are to actually sue you. Another clause that you want to have in your contracts to have a smarter contract is a testimonial and image rights authorization and liability release. That's just the word for saying that you want to be able to secure the rights to the testimonials, the reviews of your clients and customers, as well as image rights. So, what are image rights? Image rights are under law defined as publicity rights. It is every single person, even myself, you, all of us, we have the right to control how our image, our name, our likeness, our voice, how the part of us that identifies us is used for commercial purposes. That means somebody can't just use your image for a commercial because you have the right to control that and the right to profit off of it. And so for some of you, you may want to use your client's photo or even their business photo in doing reviews and just showing proof. This is how we stand out in the marketplace as business owners. It just proves a legitimacy to your business and that you're actually working with legitimate clients. And here's what they said, right? Social proof. And so in your contract is where you can get the rights. Your contract is where you secure the intellectual property rights because under copyright law, the original author of the work is the one who owns the rights. And under copyright law, if you use something without permission, this is not high school where you quote your sources. If someone owns their copyrights, they can sue you and they can demand that you take it down because copyright infringement is strict liability. The moment you do it is the moment you are liable. There is no, oh, I was just used. No, you have to follow the law. So with their testimonials, the words they write, the photos they give you, their image, their business logos, all of that falls under copyright law. And so you want to secure the copyrights to use their testimonials for business purposes. But here's the thing, if they give you something that is already owned by another person, such as their photo, they don't own the copyrights. This is why you want to have a liability release to release you from all liability of using their materials. This is how you elevate your contract and really protect your assets because you don't want to be sued by a third party for copyright infringement, all because you used a testimonial. The other provision that you want in your contract is a cure breach. Life happens. Life happens. We have loved ones. Sometimes there's a death in a family. Sometimes we have to take care of our children. We fall sick. Maybe there's an accident. We don't know what's going to happen. And so when you're in a contract, there are sometimes strict deadlines, things that you have to deliver. And if you don't deliver, you are in breach of contract. But if your contract, if you write in a cure breach, you give yourself a grace period to be able to resolve any breach before the contract is terminated and you have to cough up money or end up in court. So you want to write in grace into your contract by putting in a cure breach provision. Now, this is one of my favorite clauses. I read a case about this and it was a game changer and I love it. And it is a limitation on liability clause. You want this in your contract. And so I'm going to pause right here I'm going to pause right here because I want you to actually do this. Okay. So I want you, if you're watching the replay, I want you to pause this and I want you to actually look up this question. I want you to Google it. And what you're going to Google is this question. What is the statute of limitations for a business a breach of contract for a business breach of contract? What is the statute of limitations for a breach of contract in, and I want you to put Illinois. Now, if your business is in another state and you just happen to live in Illinois, then you want to put that state. So I want you to Google right now, what is the statute of limitations for a breach of contract in Illinois? And I want you to drop in the chat the number that you get. Ooh, do 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 do. Ooh, do 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 do. 10 years. 10 years. 10 years. That number, what that just told you is that a person has 10 years, or if you have another number, they have that amount of time to sue you. So we're in 2025. I told y'all this year will be 10 years that I graduated law school, practice law. So that means that if you had a client in 2016 and that client is long gone, y'all, but there was an issue. They still have time in 2025 to come back and sue you. So someone didn't get what you offered them. They still have time to come sue you now in 2025. I want you to think, do you still have text messages from 2016? Do you still have emails from 2016? Do you even know what you were doing on this day in 2016? What you were wearing? Chances are you don't. Some of us don't even remember what we had on last week. Okay, if you don't have that information, that means you don't have the evidence to properly defend yourself in court. And so, if you don't have a limitation on liability in terms of time in your contract written in, what happened is that state law will govern. That means that now they have 10 years where in your contract, this is how we elevate legal protection, and you have a smarter contract, you can legally limit the timeline that they have to sue you, which means that you can limit the time, ideally, to 1 year. So if they don't bring a lawsuit, they don't bring the issue up within 1 year, it's forever barred, meaning they cannot bring it up. When you write that particular language into your contract, and there's some other pieces as well that needs to be in there, what happens is that if they try to go to court and sue you, the court will say, well, we're looking at the four corners of the contract. We can't read into the contract what's not there. And so what they'll do is they'll say, well, it says here that you had 1 year. So when did that time start? And if the clock ran out before they sued, they will kick the case out. And if they try to move forward, this is where, if you have a good attorney or you yourself can petition, they dismiss the case based on that. Now, other ways that you can limit liability aside from just time and limiting the ability for someone to sue you from, in Illinois, Nick said 10 years, from 10 years to 1 year, you can also limit them on damages, that they can only recover for actual damages. There are many different types of damages. And so you want to make sure that only the damage they actually suffered is what they can actually recover for. And then the next piece that's a game changer is amount. What is the amount? If you have a 20K deal, do you really want them to be able to sue for 20K? And so you could limit the amount of recovery. And oftentimes you want to be reasonable with the amount that you choose based on the deal, but you want to limit that recovery. Now, when I talk about limitation of liability, I'm not talking about you limiting your own ability to recover for liability or things that happen. I'm talking about limiting the other parties. So you don't want to make the mistake of trying to do this yourself. If you try to do this yourself, and what would have been a smart clause, you turned it into a dumb clause because now you limit your own self 1 year to bring any case case or issue against your client. You want to have the full rights to litigate, but you want to limit their ability to do so. And then one of the most important clauses you want to have in your contract to really protect your assets and secure them is intellectual property. Now, I mentioned that without a contract, you cannot transfer intellectual property rights. So that means brand photos, videos, logos. If someone else created it for you, they own the copyright. And the only way for you to become the copyright owner or your business to become the copyright owner is to transfer those rights to your business. And so you need to have that in the agreement because intellectual property, my definition of intellectual property is it is the real estate of the mind. Ideas are not protected under intellectual property law. Your ideas are not protected. The only thing that's protected is ideas that have actually been executed, ideas that have actually been made to be in reality. And so just like with real estate, if you own a house, if you have a house, what can you do with your house? You can use your house. You can sell your house and you can also rent your house, meaning you're collecting rent, monthly payments for your house. The same is true for your intellectual property. And so you can own it, but you have to have a contract. So I say it like this: if you want to own it, put a contract on it. If somebody else created the work, if you want to own it, put a contract on it. And so if you don't have a contract in place, what you'll have is a license. That means you're renting the intellectual property. And so for our time here, I can't go into all of the details of what a license entails and the rights, but understand that you can have a license but not ownership. And so when we talk about protecting your assets, you want to be clear on what intellectual property is owned and by who and what needs to transfer, and then what is a license. So when you are doing educational consulting, there are certain pieces of your intellectual property that belongs to you. And with that, you don't want to give the client the rights. You want to be able to possibly restrict their use. And so your intellectual property clause is not just about identifying ownership and licenses, but it's also about detailing what can and cannot be done with intellectual property that was created before the contract was signed, during the contract, and after the contract. Think about custody of kids. When there is a divorce, we have to deal with legal custody. And so, in a business relationship, in a contract, there's a business relationship being created. And when there is a termination of that relationship, or when that relationship ends, we have to deal with the custody of the children, the intellectual property. And so, you want to be clear on who owns what, who can do what. For some of you, you may have courses or other materials that you develop. Can they use those materials? Can they sell it? Can they profit of it? Can they take your materials and create what's called derivative works? And who owns those derivative works? You want to clear that up in a contract, and this is how you elevate your legal protection and actually protect your contract. And so a bonus is AI disclaimer or restriction of use. Under copyright law, anything created by AI, artificial intelligence, is not protected under intellectual property law, under copyright law. That means that if AI creates it, it's free game. Anybody can use it. And so there have been people who use AI to create their logos. Well, guess what? Now anybody can use your logo, and you don't have any rights to stop them from using it because you created it with AI. And so you want to make sure in your contracts, if someone's creating something for you, or you are using AI and you're creating something for someone else and providing services, or using AI in your systems, that you provide a disclaimer. If you're using, we use AI, and we do so within our sole discretion. And maybe you want to be generous and allow for them to actually request. You can submit a request if you prefer AI not to be used, and we will take that into consideration. But if you're hiring someone to create something for you that's going to fall under intellectual property, you want it to be a protected asset, this is where you put the restriction on artificial intelligence use. And so you may say you are prohibited from using AI unless you get our express written permission. This is how you build grace into your contract and elevate your legal protection. You prohibit the use of AI, but you also give permission that if you find that AI use is okay, then you can actually create it. actually permit them to use AI in creation of intellectual property. So that's left in your discretion. Now, one other thing that I want to put here is that AI disclaimers, you also want to have it in there for anyone who is delivering materials to you, that they have to tell you what part of those materials that AI was used for. This is giving you notice so that if you decide that you want to submit a copyright for a work or protect it through other means, that you can identify what part is actually protected under copyright law and what part you have no right to, because AI, anything created by AI, is not protected under contract law. Now, I got a little bit of information about the folks who registered for this training, this webinar. And so I want to give you a few other clauses of things to consider to elevate your contract and really protect not just you, your assets, and your business, but your family as well. Because if something happens to your business, it's not just you that gets impacted. So, for those of you who have a carrier business, you're transporting materials, here is where you want to identify protections about loss of what you're carrying, but also deal with if you're carrying products, you also want to deal with any liability issues from danger of that. If you're interacting with people, look, COVID is still around, but there are other things that you may want to consider about not being responsible for. And one of the biggest things, because I have had mail go missing, although I sent it by certified mail, what happens if it doesn't make it to its destination? You want to consider that. For those of you who are doing education consulting, you want to think about the risk of what if you give information that actually causes harm to the business? You want to build in protection for errors and omission. Maybe think about insurance. You also want to consider, again, intellectual property, but also consider in your consulting work, what is the scope of representation? So oftentimes what happens when you're doing services is people like to add on things. I like to write into my services. If it's not written in the contract, then a separate contract is required along with an additional fee. That way you're not being taken advantage of. If you're in real estate development, look, there is liability for harm that happens on that property. And so you want to put in protections for with contractors on the property. What happens if they get harmed? What happens if somebody is negligent? The contractors, maybe they're building something for the real estate. What happens if they're negligent in that building process? Who is liable if you get sued later on or fined by the city or the state? You also want to pay close attention to language that says that you are jointly and severally liable. Why? Because what that says is that if you are jointly and severally liable, that even if the business is a party to the contract, you in your individual capacity can still be held liable. You want to avoid that. And you also want to think about what happens if a project goes amiss and it goes into default. Now, next is if you are, for those who are in specialty gaming equipment, you want to be mindful of what happens if they're for liability for injuries. So if the gaming equipment it's a product is in someone's hand, there's a whole law of product liability. There's a whole law on what happens when products cause harm when it's shipped to someone else. You want to be clear of what you are going to be liable for, but also what representations and warranties are you providing. Essentially, what promises are you providing? And then look at the law for what is already included immediately as a representation or warranty, and see what can you opt out of and say, actually, I'm not warranting this, because a warranty is another guarantee. It gives them another reason to seek lawsuit if you break that warranty, if you breach it. It gives another legal right. And so the last category of industry that I had registered for today's presentation is media production. And so anyone doing media production, one of the key areas you want to pay attention to is intellectual property. And you want to make sure that you're clearing the copyrights, that you're clearing use, that you properly identify the copyright owner, the copyright holder, and any copyright license, that you get the right licenses, you get the right permissions, you identify the correct parties. And And you also want to build in protections that if there is copyright infringement, or someone gives you copyrighted material and they don't have the proper permission or license, who is responsible for defending you? This is where an indemnification clause come in, that they have the responsibility to protect and defend you in that contract. Now, one thing that I had kind of glossed over when it comes to intellectual property is understanding this. The original owner owns the copyright. If you don't have a contract in place with your business, you have an LLC, a corporation, or partnership, and you don't have a contract in place that says that the business owns everything that the owners create, then that means that you in your individual capacity are the copyright owner, not the business, you. Unless you are a W-2 payroll employee for the business, you in your individual capacity without a contract is the copyright owner. That means that if you're trying to do copyright licensings or transfers and you just have the business name, it's an invalid, null, and void transfer. It's empty because your business doesn't own the right, you in your individual capacity. And so you do that, you can do that two ways. You can give your business the rights to the copyrights you create for it through your LLC operating agreement. You can write that clause in and sign it, or the governing agreement for a corporation, which is a shareholder agreement, or the shareholder agreement, or for a partnership, the partnership agreement. You write it into the contract. Now, if it's someone else you're trying to get the copyrights or you're trying to send it, then you need what's called an intellectual property assignment, agreement, or a trademark assignment transfer, or copyrights assignment or transfer. But assignment and transfer, they have two different definitions and two different operations. Now, because of time, I can't go deep dive into that, but I wanted to give you those individual considerations for clauses to really elevate your legal protection of your contracts and protect your assets. And so I mentioned anything created by AI is not protected. So one mistake that you can make is thinking that, excuse me, that contracts are one size. Contracts can be used for anything. But the reality is that you need business contracts that fit the particular situation, the particular area for which the contract is procured. And so a contract is not one size fits all, because service agreements are not the same as independent contractor agreements. The operations are different and they have different functions and different clauses, even though some of the clauses will overlap. And so here are some type of different examples of contracts that fall within different categories. These you can take screenshots of because it's just giving you the contract. So you can have, these are the different contracts under partnership and business formation, intellectual property, website and app contracts. You have workforce complex, employment and workforce. You have sales contracts, real estate contracts, vendor and supplier contracts, technology and IT contracts, and even contracts that fall under financing and investment. You also have contracts that deal with business operations, contracts that deal with just miscellaneous areas like memorandum of understanding, letter of intent, exclusivity, agreement, indemnity agreement. You also have contracts that deal with confidentiality and data protection contracts. Look, one of the things that you need for, especially when we talk about confidentiality and data protection, your website needs a website privacy policy. Your website needs terms and conditions, because that protects and helps you be compliant with data privacy and protection laws. If there is a breach of information, now you have complied not just with the U.S. laws, but also international laws, because you cannot control who comes to your website or who comes into your email list and the information you download. The moment they do, you are already subject to their laws on data privacy and protection. You also have contracts on event and entertainment, mergers and acquisitions. Merger and acquisitions are when companies are merging together, or one company is acquiring and then consuming another company. You also have services on consulting and professional services, and then dispute resolution contracts as well. So business contracts have to fit the main area and the subject matter of the situation, the deal, because not all of these contracts operate and do the same thing. And so, what contracts are a good fit for your business depends on your industry and needs. Because not just because someone is in the same industry, they may not be operating their business the same way. And so, your contract deals with mitigating risk, identifying what can and cannot be doing, but it's unique to the situation. And so, you have contracts for services, but a service can be speaking, it can be intellectual speaking, it can be coaching, it can be consulting. All of those are speaking services, but they're different. You also have contracts for intellectual property. If you're trying to acquire, get the ownership rights of works that are created by another business, this is where you use that agreement. Podcasts. If you don't have a podcast, if you have a podcast, you don't have a contract in place, your guests can have a copyright created in the podcast episode they do. They can also remember image rights, publicity rights. They can tell you, you know what, I don't like that episode, take it down. I don't like this, edit this. You want to be able to secure the rights that I get to do this the way I want to do this. And then remember, I said that ideas are not protected. And so you can protect ideas with a non disclosure confidentiality agreement. You also, some states require that you have an LLC operating agreement. So you need, that's how you operate your business. It's the contract for your business. And even if you don't have one, then that means state law applies. So you still have to operate according to state law, but you can opt out of those provisions by having an LLC operating agreement. Or if you have a corporation, then those contracts. And of course, I mentioned your website privacy policy and website terms and conditions. These are contracts that protect you so that you tell people this is what you can and you can't do on my website. And if you have an app, the same is true, terms and conditions. If you're selling anything, terms and conditions. So again, we're about to open it up for Q&A. So if you have questions, prepare your questions. You can download this free resource because having smarter contracts require that you ask the right questions and draft around that for better protection. And so you want to think about what happens if your client dies. Do you have to issue a refund? What about you if something happens to you? What about someone you paid to do the work for you? What happens in those situations? And that's where we get into drafting your contract. So 8 things you better hope your contract covers just takes you through asking certain questions so that you can really think through, does your contract actually protect you, and does it protect your assets? And so you can get that by going to the link bit.ly/the number 8 things Bronzeville. That's all lowercase, 8 things Bronzeville. All right, questions, questions, questions. Do we have any questions?
Remember, everyone, so you're going to type them. Fantastic work or presentation, of course, Shayla. If you all have questions and you're not able to type in the Q&A section, you do have time at this point before we close for the day. You can raise your hand and I can give you the ability to ask your question aloud. Any questions? I know that Shayla shared some fantastic information that you are probably still processing. But before we go, you have the opportunity to ask a final question or questions.
And if you don't know, if you're not very sure of what your question is, you know you have one, you can still ask it. That's my responsibility to help you get the question clear so I can answer it. But if you don't have questions, then you can drop in the chat. What were your takeaways? What stood out for you? What's one thing that you're going to implement to elevate your contract? And put that in. Just share that. Or any feedback that you have about the presentation, you can add that in the chat.
Great.
All right. Well, if that's all, I want to thank you for attending, registering, watching, and staying to us to the end for smarter contracts, protected assets, elevating your legal protection. Make sure you grab the free gift. I've heard great things about it. And so you don't want to leave your business unprotected or without a contract. And if you don't have a contract, please get a contract in place. And my company is one way that you can do that at 180contracts.com. So thank you so much. Stay connected. Stay connected. Stay connected. You can take a screenshot of this. And once you are on our email list, every first Friday, we give you legal goodies about about contracts, and we also do educational presentations on different areas that are related to contracts as well, because having a contract is one thing, but knowing how to use it and how to do contracts better is a whole other thing. Because this is not just about your business, this is about your wealth, this is about your legacy, and this is about your family. All right.
You
So
go
thank
to
you
that
so
last, I'm sorry, there you go. All right. Yeah,
much.
that one. Contact us for appointments. Thank you, Shayla. Everyone, I think you would agree that it was a fantastic presentation, and I have a feeling, even though you may not have typed in the chat, you learned some things. And one thing I know you should remember is if you want to own it, put a contract on it, as Shayla said. If you're not already a client with us at the Illinois SBDC at Bill Bronzeville, you can contact us via email, the website, or call. But ultimately, to sign up to become a client, you need to visit our website at billbronzeville.com/SBDC. And then, as Shayla mentioned, and hopefully you took the screenshot, you're able to connect with her and the wonderful tool that she's offering, but you can also see her email, website listed there. And so you have multiple ways to contact us both. You will receive a recording of today's training, and that will come with a request for you to complete a survey. Please share your insight about today's training, as well as there will be space for you to type recommendations for future training. We like to provide sessions that are really relevant for business owners like you so you can apply the knowledge and continue to flourish in your business. Thank you again for your time and attention today, and continue to have a great day and week. Here's to having very smart contracts and making sure you elevate that your legal protection. Thanks again, Shayla. Take care, everyone.